I think that this case is exactly what I told you that this case would be in the beginning. The state is telling you a story, a narrative. The state conceded to you from reading its own indictment that it can't prove its case because its own indictment tells you that Joe died in an unknown manner and means. Ms. Vargas even told you in opening, quote, something happened that made that man's blood sugar crash. She even just told you in closing, I can't tell you what happened. The medical examiner, her boss, her colleagues, all told you that Joe died in an undetermined manner. That is, not a homicide. Joe suffered from severe medical problems. 1, uncontrolled type 1 diabetes. 2, severe heart issues. 3, peripheral neuropathy. 4, sleep apnea. And 5, intestinal issues. Meanwhile, Sarah was under the influence of multiple narcotics from a recent breast surgery. The law is unequivocally clear that Sarah had no duty to act. That is, a failure to act is not criminal. Although, I do concede it's not good practice. It's not good practice. Joe administered that insulin to himself. Why else is the state focusing on all these extraneous acts rather than focusing on the indictment? It's because they can't prove the case. Now, I'm going to go over some pieces of the charge with you. If you look at page 4, it says all persons are presumed to be innocent and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. Remember back in jury selection, we talked about how wrongful convictions occur. And each and every one of you told me that wrongful convictions occur. How do we prevent wrongful convictions? We prevent them by enforcing that burden of proof beyond a reasonable doubt. Remember, I told you back in jury selection, if I'm the state and I'm trying to involuntarily take your child away from you or involuntarily have you committed to a mental institution, on a scale of 1 to 10, everybody said they would want a 10. And that is under a clear and convincing evidentiary standard, which is a lower burden of proof than proof beyond a reasonable doubt. Deliver your verdict with a clear conscience. How do you deliver your verdict with a clear conscience? You do that by enforcing the burden of proof beyond a reasonable doubt. What does it feel like? Well, maybe you thought you locked the door, you forgot to go back and check the door handle, you're driving off, and you have a nagging feeling. If you have any sort of nagging feeling, you do not have proof beyond a reasonable doubt. Finally, I want to take on this notion that it must be true because the state says so. And why else would the state be investing all this time, money, and resources? Well, that assumes that the state is altruistic or the state is selfless. But the state has motives. Their motive is to justify 1, the arrest, and 2, the filing of the indictment. The state is a plaintiff. The state filed a lawsuit against Sarah. Sarah's not on trial. The state is on trial.
Your Honor, this is a misstatement of the law.
Move on.
The state is on trial because they are a plaintiff and they filed a lawsuit against Sarah.
This is a misstatement of the law.
Sustain. This is a criminal case. Move on.
The state has to prove their case beyond a reasonable doubt. The burden for the state is a high burden. It's such a high burden because the very principles upon which this government were founded are at stake. Life, liberty, and the pursuit of happiness. Also, the law provides that a person who omits to commit an act does not commit an offense and has no duty to act. Page 2 of your jury charge. A person is criminally responsible if the result would not have occurred but for her conduct. Conduct includes an act, omission, or possession. A person who omits to perform an act does not commit an offense unless the law provides that the omission is an offense or otherwise provides that she has a duty to perform the act. With respect to murder, the law does not provide that an omission is an offense or otherwise provides that she has a duty to act. Every offense, it requires conduct, either 1, an act, 2, omission, or 3, possession. The law is unequivocally clear that Sarah's failure to render aid or assistance is not a crime. Notice this was law enforcement's initial theory. That's why Detective Rocks was initially charging this case as a criminally negligent homicide. Notice that Jeannie, she told Detective Rocks in that January 9, 2023 email that Sarah had intentionally left Joe to die. Not that Sarah administered insulin to Joe. She didn't allege that because there's absolutely no proof. None. Notice that it's even law enforcement's false belief that Sarah had a duty to act. Officer Yeatman told you so, but that's not the law. The law is unequivocally clear that Sarah's failure to render aid or assistance is not a crime. It's not good practice, period. It's not good practice, period. However, the law unequivocally provides that it does not make her criminally liable. We discussed back in jury selection, what if I was a surgeon, the only board certified surgeon, Chambers County, we're rubbernecking on the highway, I see a man dying on the side of the road. I choose to go ahead and keep driving and go play golf rather than render aid or assistance to that man. Detective Rocks cannot come back and prosecute me. Am I a bad person? Yes. But Sarah is not on trial for being a bad person. She is on trial for allegedly administering insulin. Her kids told you that she's a bad person, but that does not make you a murderer. She's on trial for murder, not for being a bad person. The policy behind that law is that we should only hold people criminally responsible for what they do, not from what they omit to do. Thus, Sarah can only be held responsible for Joe's death if it's proven beyond a reasonable doubt that she administered insulin to him. And one, she didn't do that. And two, there's no proof, none. The prosecutor even told you that. In closing, the state knows this. That's why they want you to focus on all of this unsubstantiated innuendo. So, looking at the charge, you are not to consider evidence of such a wrongful act at all unless you find beyond a reasonable doubt that the defendant did in fact commit the wrongful act. Even if you find that the defendant committed a wrongful act, you may consider the evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person and for this reason was likely to commit the charged offense. The state is like a magician. We all like magic. It's cool, but magic is not real. What does a magician do? They have you look over there while they deceive you while they're doing something over here. It's the sleight of hand, smoke and mirrors. What did the state do? They trotted her children in to call her a bad person. The state wants you to look at all of this unsubstantiated innuendo because they have no evidence that Sarah administered insulin to Joe. We spent half of these days on extraneous offenses calling Sarah a bad person, but they still can't prove that Sarah administered insulin to Joe. How many people testified to extraneous offenses? What, like 20? How many people testified that Sarah administered insulin to Joe? 0. They have presented no theory. The closest they got is Miss Vargas's concoction that Sarah administered some potion to Joe. But wait, it was the hospital that administered benzos to Joe. The second closest was last week in the middle of trial. Miss Castaneda told Miss Vargas that Sarah had told her that she put something foul in water that Sarah gave to Joe. But she didn't tell the police that. She didn't put that in her sworn affidavit. She just brought that up conveniently in the middle of trial. First, the state cannot prove beyond a reasonable doubt any of these extraneous offenses. FBI investigation into Heather Donahue, no arrest. The assistant U.S. attorney concluded it didn't happen. That's why he didn't indict it. All he needed was probable cause. David George recanted and said Sarah wasn't involved. Notice that David George didn't say he wasn't involved, just that Sarah wasn't. Grandmother's house fire, no arrest. The police and fire marshals investigated and concluded Sarah was not at fault. Titus Knerchel, gasoline on house, no arrest. Law enforcement did nothing. Titus's wife was never brought up in the statement to Detective Rocks. It only came up for purposes of trial. Brian Altus house fire, no arrest. Law enforcement and insurance company concluded an electrical outlet caught on fire. David Bragg, no arrest. The district attorney in investigation concluded it was self-defense. The self-defense determination is ironclad. The fact that the state is so off base on the self-defense shows you how the state is so off base here. Go back and read that. That is an ironclad letter that the county attorney provided. He said he reviewed the whole case. And you know what? What Sarah said happened actually matched the evidence on the scene. The projectiles from that letter matched exactly what Sarah said took place. Second, none of these extraneous acts can be used to conclude that Sarah is a bad person and is more likely to have committed the offense. Ask yourself, why did the state spend so much time on evidence that has nothing to do with the indictment? Because the state's own indictment tells you, after all the investigation, the state can't prove that Sarah administered insulin to Joe. In fact, they put that the manner and means are unknown. Why didn't they put in the indictment that the manner and means was due to Sarah administering insulin to Joe? One, they can't prove it. And two, they want you to contemplate convicting her on her failure to act. But the jury charge tells you you can't do that. Let's look at the real evidence. We learned that Joe and Sarah, they had been together for approximately 13 months. The family hated Sarah. Helen had a World War III with Sarah, and that was, quote, the end of the road. Jeannie also had a World War III with Sarah, and she conceded to you that she, quote, hated Sarah. Now, we know that on December 26 of 2022, Sarah had a breast implant removed. She got out of the hospital on December 28th of 2022, and she was prescribed a lot of serious pain medication, 1 hydrocodone, 2 Valium, and 3 gabapentin. She also had a drain on the left side of her body, which made it difficult for her to move. She came home and she got into a fight with Joe. She was so upset with Joe because the house was a mess. This led to Joe aimlessly driving around. Jeannie told Joe, you can't do that. You have severe diabetes, you go up and down, you need stability. So she implored Joe to come home, which Joe did. Now, Joe was unquestionably thinking about going separate ways from Sarah, including opening a personal bank account. Joe didn't fear death or that he would be killed by Sarah. This is evidenced by the fact that he went home and stayed there. But his family did express concerns to Joe based on that prior self-defense death and the FBI incident involving David George. That's why Joe left that voicemail in a joking manner that he didn't get shot. Now, it is possible that in between December 29th and January 6th, they reconciled. But we don't know that. In fact, we do know that Sarah was making other plans as well, but the bottom line is that we don't know if they were going to definitively divorce. In fact, Joe's own mother told you that when she was at the hospital and she told Sarah that Joe was going to divorce you, she was shocked. On January 6, 2023, Sarah was still on her pain meds. Joe returned early in the morning from work, and he went to a job interview in the Woodlands, returning home in the early afternoon. He ate rice, broccoli, and cheese that Sarah made him, and he went to bed. Sarah did say that she passed to him her long and short-acting insulin pens. Joe's diabetes, according to Dr. Knight, was, quote, very severe and, quote, very uncontrolled. His own family and Dr. Inakua all agreed that he had severe diabetes. Ladies and gentlemen, he was hospitalized 3 times overnight for being DKA. This wasn't like his dad, who, remember, his dad was hypoglycemic, and he literally he got helped in the EMS vehicle. No, Joe had to go to a hospital overnight 3 times to literally save his life. 2 of these overnight hospital visits were within 1 year of his passing. The state and these professionals, they argue, oh, he was just scared of being low. No, that's not the explanation. The explanation is that he did not give a you-know-what. In fact, he should have just been scared running high, considering that he was hospitalized 3 times, including twice within the year of his passing. Joe, he lived his life like he didn't have severe diabetes, which is exactly why he was also suffering from severe complications, such as 1, heart issues, 2, peripheral neuropathy, 3, sleep apnea, and 4, intestinal issues. Dr. Nakawa even noted that although he normally ran high, she had to closely monitor Joe because there was a risk of severe hypoglycemia. So up here you can see the patient required frequent, I'm going to read it, it's really difficult. The patient required frequent adjustment of medication and close monitoring due to risk of severe hypoglycemia. And that's from the 7/15/2022 date you can see. She put it again in another record. This is from the 9/29/22 visit Joe had. Patient required frequent adjustment of insulin regimen and close monitoring due to risk of severe hypoglycemia. This is because she was administering him high amounts of insulin, and she feared insulin resistance. So here, on 7/15/22, his insulin requirement is very high and raises suspicion of insulin resistance. 7/29/22, uncontrolled type 1 diabetes for many years, his insulin requirement is very high, which raises suspicions of insulin resistance. 9/29/22, his insulin requirement is very high, which raises suspicion of insulin resistance. 11/29/22, DM1, which is type 1 diabetes, low C-peptide, peptide with high insulin resistance. This led to her prescribing high amounts of insulin and metformin, which medication made him even more sensitive to insulin. Dr. Knight confirmed to you as well that he was receiving a high dosage of insulin. In fact, the last time she saw him, Dr. Nakawa, she increased the insulin amounts even higher, doubled his metformin, and told him to email her once a week, no doubt to monitor that high dosage of insulin. So clinical notes, increased Lantus 40 units twice a day based on his report of 60 daily, not improving his BG, blood glucose. I asked him to email me once a week. Ask yourself, how often have you ever had a doctor, or do you know of a doctor who wants you to contact them on a weekly basis? It's not Dr. Inakawa's fault. She was basing the amount of insulin she gave based upon Joe's words and the fact that he was persistently running high. Now notice, she did testify that if someone is not taking their insulin and all of a sudden starts taking their prescribed amounts, it could, quote, cause hypoglycemia. Question. If somebody's not taking their insulin and then all of a sudden starts taking the prescribed insulin amounts, what sort of effect does that have on a person? Answer. It could cause hypoglycemia. She then added on her own, quote, so if they go from taking only, for example, 20 units, they start to take 40 twice a day, they would have hypoglycemia. Quote, so if they go from taking only, for example, 20 units, they start to take 40 twice a day, they would have hypoglycemia. She also added, this was unquestioned, she added this, quote, Lantus is once a day always, regardless of the dose. But if I gave him 80 once a day and he has hypoglycemia, it would be difficult to reverse. Sometimes when we split the long-acting, the low hypoglycemia. So if I gave him Lantus is once a day always, regardless of the dose. But if I gave him 80 once a day and he has hypoglycemia, it would be difficult to reverse. Notice, this is exactly what happened to Joe. Now, those long and short-acting insulin pens, they have units that you have to dial. We don't know how much long-term or short-term acting insulin that Joe administered. We see that Joe, he turned into hyperglycemia, high, and he took his long and short-acting insulin. Notice how he fell precipitously. Quite frankly, he could have taken that 80 units of Lantus in one dose. We don't know. We don't know. But we do know that Dr. Nakawa said that if you're not taking your insulin, you can become hypoglycemic if you start using your insulin as prescribed. Also, Dr. Nakawa, she conceded to you that she was prescribing an irreversible amount of insulin should Joe become hypoglycemic. And notice, Dr. Nakawa was not some hired gun. I didn't go out and go find some expert to present a novel theory. She was a fact witness here in this case. In fact, she called Joe even an expert in managing his diabetes. I think each and every one of you know that he is anything but an expert in how he managed his diabetes. Now, we definitively don't know that Sarah administered insulin to Joe. Ms. Vargas has told you that, even in closing. After all the evidence, she told you. We don't know. However, Sarah is adamant that she didn't. She says that when she found him unconscious, she telephoned for emergency assistance. She says she found him at 1 o'clock to 1:30. And it's true that she did call at 2 o'clock. But she wasn't sure of the time. Her husband is on his deathbed. And Sarah is not expecting a murder charge. Deputy Yeatman responds to the hospital, and they are all accusing Sarah without any evidence of having murdered Joe. Helen states, well, nobody was upset with Sarah. Jeannie says she never accused Sarah. But the bottom line is they all accused Sarah because they hated her. Detective Rocks never considered that Joe did this to himself. That wasn't investigated. Period. There's no doubt about that. This is why the state wants you to focus on all the extraneous acts, because they surely don't want you to focus on the complete lack of an investigation. As a community, do we want our police prosecuting our families and our neighbors based on accusations with no evidence, based on an accusation without an investigatory foundation. This absolutely harks back to jury selection, where I told you, show me the man and I'll show you the crime. This prosecution is based solely upon accusations of family members who hated Sarah, and they made suppositions based upon Sarah's past. But you can't do that. It's in the charge that in a court of law, we don't allow prior alleged acts to show that a person is a bad person and is thus more likely to have committed the offense. Here we are at court, and it's still not figured out. That is, there's no proof that Sarah administered insulin. Sarah cooperates with law enforcement. She provides a statement that, by the way, the state objected to me showing you, and agrees with law enforcement to let them search her home, where she provided another statement, which the state didn't show you, I showed you. Lieutenant Hemingway, in the state apparently, is appalled that she left her husband to let them in, but they ordered her to do so. They told her, come let us in. She tried to let them in remotely. That didn't work, so she had to use her key. Rox, again, doesn't do any investigation whatsoever. She doesn't preserve the crime scene. In fact, she doesn't initiate a crime scene. She doesn't collect any evidence whatsoever. She doesn't collect any pins. She doesn't call a crime scene technician to the scene to preserve the scene. We didn't get to test any of those pins for fingerprints or DNA. Rox didn't do an investigation because her mind is made up to charge Sarah with attempted criminal negligent homicide. Why did she choose that theory? Because she can't prove the administration of insulin. But she can prove that Sarah didn't act based upon the Dexcom records. The problem with that theory is it's not a crime. It's not. Note that Officer Yeatman told you when they were in the house that there were only 2 insulin pens by Joe. Note that Lieutenant Hemingway told you that Sarah brought the other insulin pens to the nightstand. So, what were the bedside tables like? The one side I remember, I believe, was the right side of the bed, had a bottle of prescription pills. I do not recall what they were. And then I believe the boxes of insulin were on that nightstand as well. Were they insulin pens? I believe so, yes. And I won't hold you to it. I'm not going to quiz you, but about how many insulin pens were there? 2. So with your belief of that, you're saying that it was just those 2 pens that caused Joe's death? No. Okay. Were there any other pens that y'all found? Not that I found specifically, or any other pens that you saw. When we were at the house, I saw where the insulin was kept in the fridge. Okay. So you only saw those pens in the fridge, and then 2 other pens, correct? I believe so. Yes. Okay. Did she talk about moving his insulin pens? Yes. She said that she had collected a bunch of empty pens around the house and brought them and put in his nightstand, which kind of goes against her earlier statement saying that she's the one that keeps the house tidy and in place and everything. They didn't initiate a crime scene. They didn't preserve the crime scene. We don't know if those 2 pens were full or empty or anything about the other pens, whether they be on the nightstand or in the fridge. At the hospital, yes. Sarah refuses to allow the family to see Joe. However, they're all falsely accusing her of murder. How would any person feel falsely accused of such a heinous act? Irate, indignant. On top of that, Jeannie is calling Sarah the B word and telling her, quote, "You better keep walking." They were kicked out of the hospital. Now, we don't dispute that Joe died from hypoglycemia. I don't dispute that. But he also did have a heart attack. Remember, Miss Vargas told you in closing just a second ago, the medical records are clear. They are clear. 16 from Dr. Kakashani. Could be due to hypoxia/hypoglycemia cannot exclude a stroke. Page 179 of the medical records. Page 260 of the medical records. Clinical history, stroke follow-up. Page 263. What I highlighted there is very detailed, but I'm going to actually go a few sentences down to the non-highlighted. He has deteriorated. Prognosis is very poor, unlikely to improve beyond this. The reason for this presentation was stroke and hypoglycemia as well. So, it was never investigated when the heart attack took place and the effect it had on Joe's death. Sarah labeling this as a stroke continuously is a defensive mechanism for a false accusation of murder. After all, we do have an ME report that explains the manner of death is undetermined. Manner of death, undetermined. That was signed off by the ME's boss, and it was peer-reviewed. We see down there, this case was presented and reviewed at the weekly Harris County Institute of Forensic Sciences Quality Assurance and Peer Review Conference on March 15th of 2023. Regarding Joe's heart, it is important to note that one coronary artery was blocked 90 to 95%. Another coronary artery was blocked 60 to 70%. And that's straight under atherosclerotic coronary artery disease. That's right from the ME report. Thus, she concluded that Joe had atherosclerotic coronary artery disease. It's right there. Dr. Inakawa, she explained to you that this is the type of heart attack that is caused by diabetes. Question. Okay, and what is that called when that, is that a medical term for a stroke? That is ischemic stroke, infarctive stroke. When the block is, the blood vessel that feeds the brain with oxygen gets blocked because of the effect of high sugar. Okay, and what is that called again? Ischemic, okay. And I'm going to mispronounce this, but what's the difference between that and atherosclerotic? It's the same thing. Atherosclerotic. In accordance with the ME report, Joe suffered from comorbidities that Dr. Inakawa, she described. Question. What sort of effects does type 1 diabetes have on a person after 26 years? It depends on too many factors. If it's controlled, not controlled, is there any other comorbidities, smoking, other habits? There's too many factors. But after that long of diabetes not controlled, I expect some complications like stroke, heart attack, blockages in the legs, high bleeding, something called neuropathy. All of this is what Joe suffered from. The conclusion from the ME report has to remain unchanged. Comment. The classification of cause and manner of death is, in any case, is based on a combination of autopsy findings and investigative information, including circumstances and history. In this case, the decedent, a 46-year-old white male, was found unresponsive in bed on January 7, 2023, was transported to Houston Methodist Baytown Hospital, was pronounced dead on January 15, 2023. After review of investigative information, including medical records and results of laboratory testing performed at Quest Diagnostic, described above, the cause of death is classified as complications of toxic effects of insulin. At the time of the writing of this report, the circumstances surrounding the death are unclear, particularly regarding the administration of the insulin to the decedent. In addition, the law enforcement investigation is still ongoing. Should additional information become available, the manner of death may be reevaluated and appropriately amended. Notice that the ME report leaves open the possibility of changing her opinion if, quote, should additional pertinent information become available. Ask yourself back there, what additional pertinent information did the state present to the ME? The answer, again, is none. Again, the only additional information is the extraneous acts, but that is the sleight of hand. They want you to focus over there instead of here, the indictment. Like you believe in magic, they believe in her guilt. But just like magic, it's not real. Nothing has changed. There is no evidence that Sarah administered insulin to Joe. The state cannot even tell you the manner and means. They can't. They're literally throwing the kitchen sink at the wall and hoping something sticks. Well, oh well, Sarah could have given him benzos and ropinirole and Benadryl. There's no evidence of that. Well, the hospital gave him benzos. Also, Joe could have taken benzos recreationally. There's no evidence that he did that, but there's no evidence that Sarah administered any of that. Moreover, Dr. Knight explained that ropinirole doesn't make you tired. There's no evidence of a struggle? None. Joe was much stronger than Sarah. A woman who had just had a surgery is on a cocktail of narcotics. I mean, sticking a needle in somebody, you're going to feel that and react. If Sarah's sticking a needle in him, how does he not react to that? If I throw a dead body right here, right now, you want to know who, when, why, how. All of that is inexplicable based upon the evidence we have. Every doctor here that testified was aware that people have died from hypoglycemia. Granted, they didn't say it was common. But never in the manner in which the state asserts that Joe died. In fact, Dr. Inakwa praised Dexcom for saving lives because people go to sleep, become hypoglycemic, and have a resulting severe medical issue or die. All of this means, from totally inconclusive evidence, it is more probable that Joe accidentally did this to himself. Joe had uncontrolled diabetes and severe medical issues and was prescribed a lot of insulin, which he hadn't been taking. And on top of that, he was taking medication which made him even more sensitive to the administration of insulin, that is, the metformin. Dr. Inakwa told you that the amounts of insulin Joe had could make him hypoglycemic if he had been non-compliant, which he was, and a mere 80 units of Lantus would be irreversible. Also here, we are like Detective Rox wanted and ensured after only mere accusations from family members without evidence who hated Sarah with a predetermined investigation that was so lackluster that they didn't even preserve the scene or collect any evidence. Evidence was made up, literally in the middle of trial by them. This water drink, in the middle of trial, this comes up. Oh, well, Sarah told me that that there was something in water and it smelled foul, and she made Joe drink it. That came up in the middle of trial. The mix of pills, that's made up. A packed suitcase, that's totally made up. It wasn't in the police report. Do you not think it's a big deal if somebody has a packed suitcase and you don't put that in the police report? You don't take a picture of that? Sarah absolutely did not commit this crime. Here, there's still, as I told you at the beginning of this trial, Ms. Vargas confirmed it. Closing. There still is no evidence, literally none, that Sarah administered insulin. The record is replete with doubt. Render a verdict of not guilty. Thank you.